Thank you so much for joining us today. I know that Jamie Raskin is hosting a happy hour upstairs, so you guys get a lot of credit for...
Everybody's going to leave.
Well, we've got drinks behind the dais, so... Thank you so much for joining us. This conversation today could not be more timely. After the Roberts Court's decision in Louisiana versus Calais gutted Section 2 of the Voting Rights Act, this week, the court let Alabama reinstate flagrantly racist congressional maps that will disenfranchise black voters and eliminate their representation in Congress. This is an all-out assault on the 15th Amendment and multiracial democracy in America. As horrifying as these developments have been, I'm sure they surprised precisely zero of us. To anyone paying attention, it's long been clear that the game at the Roberts Court is rigged, fixed against the American people. After ushering in Trump's return to power by granting him blanket immunity for his crimes against our country, the Roberts Court has emerged as the central engine for authoritarian power consolidation in the United States. As we'll discuss today, this court majority was corruptly installed by a sprawling, billionaire-funded judicial capture campaign. Wielding unchecked and unaccountable power, the Roberts Court has dismantled the core pillars of 20th century progress. The justices have enriched their benefactors, entrenched their political allies in power, and stripped away our hard-fought freedoms. After Calais, we must face reality. No meaningful pro-democracy agenda will survive this court's review. And with the court's deeply ideological supermajority projected to stay in place until 2065, waiting for the tide to turn is simply not an option. This is what we're here to tackle today: how to unrig the game, how to clear out the rot at the heart of America's broken political system, how to stop shooting at TIE fighters and take out the Death Star. Star Wars. My name is Alex Aronson. Lisa Graves and I founded Court Accountability to confront this corrupt weaponization of our courts and build a movement to take our country back. The work we do stands on the shoulders of the people on this stage. It's going to take all of us to defeat this imperial court, and the people right here are showing us the way forward. Thanks. I had the honor of serving on Senator Sheldon Whitehouse's judiciary staff for 5 years. Senator Whitehouse is a lion of the Senate Judiciary Committee and has been the tip of the spear in exposing the coordinated scheme to steal our courts. A relentless opponent of corporate power and dark money, Senator Whitehouse has tirelessly prosecuted the case against judicial capture, driving critical oversight and reform, and making bad guys shake in their boots. As the boss would say, shots fired. We have so much to thank him for. Lisa Graves is co-founder of Court Accountability and leads our strategic research at the helm of True North Research. Lisa is a battle-tested veteran of the judicial confirmation wars. She is the author of the acclaimed book Without Precedent, co-hosts Legal AF on the Midas Touch Network, and writes Grave Injustice on Substack. She is one of the foremost experts investigating the architecture and funding of the project to capture the court. If not for Lisa, I don't know where we would be right now. She's a national treasure. Her research and investigative work are the reason we know so much about this coordinated scheme. Professors Nico Abui and Daphne Renan are wonderful individuals, charming individual people in their own right, but today they come as a package deal. They teach at Harvard Law School. You might have heard of it. Their forthcoming book, Supremacy: How Rule by the Court Replaced Government by the People, makes the constitutional case for Congress to challenge judicial supremacy itself. They're not just critiquing this court, they're laying out a path for us to reclaim our Constitution and rebuild our democracy. This book is the blueprint. Please scan that QR code, buy it, buy copies of it, send it to your friends. Other of our guests, like Lisa and Sheldon, also have excellent books that you can find on our QR code.
Cool.
Last but certainly not least, Shalila Dowdy is a Mobile native, a West Point graduate, an Army reservist who served as a major in the U.S. Army. She has shown a courageous commitment to defending the right to vote as a movement leader and as a plaintiff in the voting rights litigation against Alabama's racist redistricting. She's on the front lines of this fight, and we're going to hear from Shalila about what is at stake and how communities are fighting back. Shalila, I'd love to start with you because you are on the front lines, right? And I think too often our conversations about the court and the law happen in the context of abstraction and vagaries, in marble temples like the one at 1 First Street. So I want to ask you about the lived experience of somebody who has been fighting this fight on the ground as a community leader and as a civil rights leader in Alabama. I want to ask specifically about Black power because that is ultimately what these rulings are about and what the Supreme Court wants to take away. We had your co-plaintiff, Evan Milligan, at our panel here last year. He's a dear friend, and he told us about the incredible organizing and community building that case demanded, that it required. And I'd love to hear about your experience as being part of that case and what this ruling in Calais means for the legacy of the civil rights movement and the future of equal representation for Blacks across the South.
Thank you for the question, Alex. So as stated, I'm Shalila Dowdy from Mobile, Alabama. I am intertwined with Alabama and Louisiana. I'm in law school at Southern University Law Center in Baton Rouge, Louisiana, so I commute between the two states. But after transitioning from active duty, I returned home, embedded myself in the community, did some work with the census, worked with the Southern Coalition for Social Justice, and there's not a lot of people doing organizing work, and a key component of organizing is education. Where we are right now in this country is due to a lack of education on both sides, and so chose to join the case that was initiated in November of 2021. We had public hearings across the state of Alabama where our state legislator was supposed to, intake information from the citizens on what we wanted the new maps to look like once the census data was released. They produced a map that was identical to the map we've had for the previous 2 decades, which commenced a lawsuit. Our attorneys are from the NAACP Legal Defense Fund, ACLU, and there's 2 other lawsuits attached to Allen v. Milligan. But being on the ground meant educating people. Our community, the Black community in particular, did not know that we should have power. They did not know that we should have representation on the congressional level. And so we focused a lot on trying to educate people to look at maps. A lot of people do not look at maps. A lot of people don't know their state house district, their city council district, state senate, or what the components of their congressional district looks like. And that's all important when it comes to going to the polls and voting. It's not just great to show up, but we want to make sure we're educated when we show up. And so when the results of Louisiana Calais came out, the Supreme Court chose to hear the case. They could have chose not to hear it. And so we already had a feeling that they were going to possibly gut Section 2 of the Voting Rights Act. Unfortunately, we didn't think that it would trigger what happened across the South with Tennessee getting rid of their 1 Black congressional district, South Carolina making the attempt, and Alabama requesting to have our injunction lifted. And what we're doing now is trying to educate people on what is going on. So now we have an additional election because our state wants to steal Black political voting power from the Black community. They're pushing a partisan narrative, but for me, it's a black and white thing. It's about elevating white supremacy in our country, and the Supreme Court has played a role in that as a whole. And so what we're doing is our maps that our state has reverted back to has a 2nd district with a Black population that is 39% Black. So we're gonna focus our efforts on possibly trying to win that by turning out as many voters as we can. The problem across the country, and we have that problem in our state, is low turnout. We have 3 million registered voters in Alabama, and only 800,000 showed up in our primary that we had on May 19th. So in order to do the work, we have to educate people in the process, because people know that, hey, we were able to elect a 2nd Black candidate to Congress but they don't know that we're losing him and in what manner we are possibly going to lose him. And so we're trying to keep hope alive and focus on that district that has the second highest black population in our state. But it takes educating people and mobilizing them to understand you can't do this as a solo individual. So we're trying to push people towards organizations that have a presence, that's had a presence in our community for over hundreds of years, or over 100 years, such as the NAACP, and aiming to just go out and have the conversations on, hey, when we are not at the table, we're on the menu. And we don't believe that, hey, a white person cannot represent us because our Democratic candidate for governor is not black. And so the problem is when you don't have someone from your community at the table, your community goes unheard. I've had white, I'm trying to be nonpartisan, I know I just said Democrat, but I've had white representation in Congress. They don't come into the black community. They don't listen to our needs and wants. They don't make an appearance. It's hard for us to hold them accountable. At least when you have somebody black in these seats, they're gonna show up at a community event and you can ask them, hey, why did you vote this way on this particular bill in Congress? And we've done that with Congressman Figures before. So it's about being able to see yourself and to know that your community won't be forgotten. And what is about to happen now is if we're not able to maintain that representation, our communities will lose out on resources, will lose out on having a voice. And so we are prepared to fight forward. Right now, we do have a retrial scheduled for January 2027. So we're gonna have to go forward with the congressional maps that dilute the black political voting power, but the fight definitely still continues.
Thank you so much. Lisa, I was hoping to turn it to you to give us some context about the Calais decision itself, and where this decision came from. It was the culmination of a decades-long political project to destroy black political representation, and it didn't happen by chance. You've been my partner in this work and someone whose vision and critique of the court has informed critical coverage and public opinion. I'd love to hear more from you, particularly rooted in your investigative research work, about the scheme to capture the court, who was involved with it, how it produced results exactly like Calais, and if you can weave it in, I know you'd love an opportunity to talk about our friend, the Chief Justice of the United States, John Roberts, the worst Chief Justice since Roger Taney, and a man who's made it his life's mission to end the Voting Rights Act. So tell us about that.
Well, I'd love to, and I just want to thank you, Alex, my partner in this work. I'm so honored to be here with one of my heroes, one of my great heroes, Senator Whitehouse, and with new friends and allies, and with so many of you in the room and that are going to be watching this on streaming who need to understand what type of constitutional crisis we're in. We're actually in a multi-phase constitutional crisis, and it is not an accident. It's not a mistake. This is long in the making. I think it can be short in the undoing as we come together to deal with it and grapple with it. But the reality is that no court, no Supreme Court in the entire history of the United States has been constructed the way this court has, with the influence and spending of a handful of billionaires who have sought to capture this court because their agenda is profoundly unpopular on a variety of issues, and they could not win despite the millions they're injecting into our elections after the Citizens United decision. They knew that they could not win at the ballot box what they could win if they could capture this court. And Senator Whitehouse has been at the forefront of telling this story of capture, of using the platform of the Senate and the Senate Judiciary Committee to really make sure people understand the stakes and what is happening. In my examination of this work, which is also part of my book, Without Precedent, one of the things that I detail is how, and if you'll just bear with me for 1 second for one tiny particular part of the historical story, this day that just happened a few weeks ago, and then again this week with Alabama, is the fruition, the culmination of the lifelong mission of John Roberts. You may recall during his hearings on his nomination for the Supreme Court, he pledged to you all that he was going to be a fair umpire, just calling balls and strikes. I contended that was a lie then. It's even more of a lie today. He was chosen to be a ringer. He wasn't chosen to be a fair judge. We know that in part because of how he was chosen. We know that in part because that was the period of the no more suitors mantra from the Federal Society loyalists, that they did not want someone who was going to follow precedent. They wanted someone on the court they could count on to change it. And John Roberts this year, and again in Shelby a few years ago, what John Roberts did was use the power of the court to accomplish what he could not as a lawyer accomplish. He used the judicial power to win. And in the case of voting rights in particular, this is an area where John Roberts got the job at the Justice Department in the Reagan administration because his boss, his mentor, Bill Rehnquist, called and got him that job at the top of the Justice Department. Who was Bill Rehnquist? He was, at the time, the most regressive justice on the Supreme Court, and he had cut his teeth in Arizona, going to the black neighborhood of Bethune with cameras and instructing other Republican lawyers to go with him to intimidate black voters. When he was called on this, he first denied it. Then he claimed he wasn't intimidating black voters, just Democrats, who just happen to be black, which is part of the theme that we'll see coming through, that we've seen coming through this so-called jurisprudence of this court. So Bill Rehnquist calls Ken Starr. He was the chief of staff for the Attorney General of the United States, asked him to hire his clerk, John Roberts, who his fellow clerk said that John Roberts was extraordinarily aligned on civil rights issues, meaning anti-civil rights issues, with his boss, Bill Rehnquist. What job did John Roberts get? He got the job managing the effort to stop Congress from overturning a terrible decision of the U.S. Supreme Court from Mobile, Alabama, the Bolden case, that Rehnquist joined. And that decision was about whether the courts could take into account the effects of changes in the law for a violation of Section 2 of the Voting Rights Act, not just the intent. And what Rehnquist and his buddies had done was say, no, 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 intent only. So only if someone says the N-word, only if someone expresses out loud the racism in their heart could you find a violation. And Congress knew that was wrong, so they were determined to overturn it. But Roberts spent hundreds of hours trying to stop them from overturning it, and he lost that battle. The Voting Rights Act was extended until 2007, just in time for John Roberts to join the Supreme Court. He was confirmed in 2005. By 2011, 2012, he had started to take back up the voting rights challenge in the Shelby County case, where he destroyed Section 4 and Section 5 of the Voting Rights Act arrogantly without any factual findings, ignoring the factual findings of Congress. And he did so in order to destroy that part. And now this year, he's come back for Section 2 and handed the pen to Alito to do so. Now let me just briefly recap the money, because people do not understand how we got here. This wasn't just conservative judges versus liberal judges. This wasn't just Republicans versus Democrats. This is a position that the Republicans were coveting to capture the court. With Roberts, it was the first time we saw really big money, dark money coming into a nominations battle. It turns out in hindsight that Harlan Crow was one of the funders. We didn't know who he was back then. Now we know that he's the benefactor of Clarence Thomas. Back then, before Charles Koch was famous, what was Charles Koch doing? Helping to get John Roberts and Sam Alito on the court. Fast forward a few years, Citizens United, that decision happens. Suddenly, who's on that? Who's so excited to move that case forward? Charles Koch, one of the richest men in the world, before we all knew who he was. What happens in that case is that Clarence Thomas sits on a case, even though Harlan Crow gave his wife, Jenny Thomas, $500,000 just weeks before that decision was issued to fund a group to take advantage of that decision. Clarence Thomas did not recuse from that case. It was a 5-4 decision, illegitimate in my view on its face. And Thomas had the audacity to issue a concurring opinion in which he said, not only is money speech, and not only can we overturn campaign finance laws and claim that they're a violation of the First Amendment, but also disclosure would chill the spending of free speech, and so we should not have disclosure, knowing that his wife had received $500,000 from his billionaire buddy. Fast forward to the Trump nominees, again, massive money coming in, Leonard Leo at the helm of wielding that money like he did for Alito and Thomas, helped install Gorsuch, helped install Kavanaugh and Barrett, despite all of the serious problems with those nominations. And here we are today with a captured court aggressively overturning our rights in alignment with this handful of billionaires who have sought to capture the court in order to advance their agenda and, in my view, harm our democracy. And I will say this in conclusion. This captured court, this court that has been corrupted by this money, this court that has been targeted to accomplish this agenda, this extreme agenda, this court will continue to dismantle our rights until we stop it, until we move forward a profound and bold reform agenda built on investigations and oversight and community conversations about how we cannot have a real democracy if we cede the power over things like our voting rights to a court that was designed by these billionaires and the operatives to give them results that deny our voice.
See what I'm talking about? Senator Whitehouse, I want to make sure we have time in this conversation to talk about how the Congress will respond to Calais and advance protections for all people to vote. We need political equality in this country, and we do not have that today, and it falls to Congress to advance that, and Calais is going to be a huge obstacle to our ability to do that. But I don't want to leave this theme that Lisa left us on around the incredible conflagration of corruption and scandal that has taken hold of this court over just the last few years. We have come to learn about the decades-long scheme to capture these justices. Thanks to investigative reporting and your oversight, Senator, we learned that billionaires with huge financial and political interests before the court were peddling justices with free RVs, school tuition, luxury hunting trips, a fishing trip to Alaska because there was a seat on the private jet that was otherwise unoccupied, so Justice Alito needed to fill it. He was flying an insurrectionist flag outside his home while he was sitting on the case to consider whether Trump had committed an insurrection. These justices are also routinely breaking the law. Your oversight exposed what appears to be outright tax evasion by Clarence Thomas and billionaire Harlan Crow. Sam Alito scoffs at the federal recusal statute. It's a mandatory recusal statute. Exposing all this corruption has been a huge public good in its own right, but at the end of the day, none of the justices or their billionaire buddies are really being held to account. They're shredding our Constitution, and Justice Alito claims that no provision in the Constitution gives Congress the authority to regulate the Supreme Court, period. Like the president, they clearly think themselves immune. Senator, do you accept that view? What does that leave of checks and balances when you become chair of the Judiciary Committee? What would be your oversight agenda? How will you take this on?
Let me start by saying that everybody in this room and listening to this has a role to play in the question of whether I become the chair of the Senate Judiciary Committee, so pay attention to November. Either way, I'll be ranking member if I'm not chairman. Congressman Raskin is here also. He will be the chair or ranking member of House Judiciary, and we're already talking to one another about what that looks like so that we can move forward in concert and be as effective as we can against the capture of the Supreme Court and the long-standing scheme that accomplished it. I put our goals, our immediate goals, into three buckets. One is investigation. Congress has powers of oversight, and those powers of oversight give powers of investigation, and there is a lot to look into. We still don't have an answer, as Alex pointed out, as to whether Clarence Thomas ever paid taxes on the income he received when his $250,000 motor coach loan was forgiven. This is a question that has now been pending for years, and it's super easy to answer. Yes, I paid this much on this date with this money. And the fact that they can't produce that answer, they won't produce that answer, is a tell. I would also argue that it's unlikely that an individual has declared income on his personal taxes and then omits declaring that same personal income in his judicial disclosures. And we know that he did not disclose it in his judicial disclosures. So there's some pretty big hints out there of something amiss, and we need to get to the bottom of that. That's a fairly simple task. There's a slightly more complex one, which is, who was really behind Trump's appointees? What's the real story there? Because it looks a lot like the House of Koch, the Koch brothers' political operation, was at war with the House of Trump as Trump tried to get elected. And suddenly that war ended. Somehow a truce was negotiated. And at around that same time, somehow, a list of Supreme Court nominees, described as the Federalist Society list, was produced. Well, we do know that the Federalist Society never considered such a list. It was never on the agenda. It was never debated. It was never voted on. The word Federalist Society list is camouflage, very likely, for a deal that was cut between the Koch brothers and the Trump campaign that they would shut up about Trump and leave him alone to run if he would give them his Supreme Court nominations. And of course, they couldn't call it that, so they had to call it a Federalist Society list. And they needed the list because the Kochs know better than to believe Trump about anything. So a promise from him is worth nothing. So something public had to be done, hence the list. And then the Koch functionaries, Leonard Leo and Don McGahn, become the two people who, from White House counsel and from the outside, then choose the names off the list. There's a lot to dig into there and tell a story about what really happened behind these appointees to the court. And that opens to the larger question of the whole court capture scheme all the way back to the Powell memo. It is a long story, but if you look particularly at Lewis Powell, you see how inch by inch, step by step, Republican Supreme Court justices and only Republican Supreme Court justices have opened the door to corporate political influence, from the Bellotti decision years and years and years ago to the final culmination of Citizens United. So terrific long story to be told about that capture program and how it moved power from we the people to corporate interests. The next step is going to be looking into their ethics rules. Unlike every other Supreme Court, they will not submit themselves to any fact-finding. If you guys have an ethics complaint against me, you can file it with the Senate Ethics Committee. And the Senate Ethics Committee will do an investigation. There will be fact-finding that gets done. That's true of every person in government, except 9 Supreme Court justices who won't tolerate fact-finding about their conduct. Well, fact-finding is the foundation of the rule of law. There has to be fact-finding, and all 50 state Supreme Courts have figured it out. So we're either going to put them in a position where they're under a rule that includes fact-finding, or they will have had to create their own under that pressure. But we can no longer be in a situation in which an ethically challenged Supreme Court has a defective ethics code that doesn't even have fact-finding. And then the last bit is going to be looking at term limits. Term limits, particularly if you apply them retroactively, allow for a healthy turnover in the court. They eliminate the problem of the duty to sit, because somebody with a conflict of interest can just step out of the panel and you go to the senior justices whose 18-year term limits have expired. They come back and they hear the case if they don't have a conflict. And that also separates out the constitutional cases that are the court's constitutional jurisdiction from its appellate jurisdiction, which is what we think about when we think about court decisions, but which is a power that the court only has because Congress gave it to the court. So we'll have a lot of work in front of us, and as I say, the foundation for getting those good ethics and term limits and other legal changes is to have a really good public understanding of exactly what the hell went wrong in this court.
If I could just follow up quickly on that. I think that sounds like exactly what we need to do. And at the end of the day, I think we're also dealing with justices who don't believe the law applies to them. Everything they've done suggests that. And so my question for you is, what are we going to do when we advance this reform agenda, when we pursue this oversight, when we hopefully issue subpoenas to Supreme Court justices to bring them to answer these questions in front of the country in Congress? And they tell us, you don't have the authority to do this. Congress can't regulate the Supreme Court, period. What can Congress do then?
A certain amount depends on how well coordinated this is within Congress. Because one thing that the Supreme Court absolutely has to do is come over to the Appropriations Committee and get its money. And I don't think there's any doubt that the Appropriations Committee has authority to appropriate money as it sees fit. That's the power of the purse. So if the Senate Judiciary Chairman is working closely with the Senate Appropriations Chairman, we are then in a position to apply some very real pressure to them. They're also in a bit of a predicament, which is that if they consider what we do to be unlawful, somebody has to file that lawsuit. And that lawsuit is first going to go to district courts and then to circuit courts of appeal. And in my experience, circuit court judges and district court judges are really not amused by the mischief that the Supreme Court justices have gotten up to, and how they all have to go home and answer for judicial misconduct that they would not be allowed to do because they're under proper ethics rules, but the Supreme Court insists on getting away with because nobody can find the facts that prove they did anything wrong because they've exempted themselves from proper fact-finding. So there's a long and ugly road before the Supreme Court gets the chance to throw this out. And when I say ugly, I mean ugly for the Supreme Court justices.
Trump has been in the business of moving buildings, renaming buildings. One thought is we could convert the temple on 1 First Street into a museum to the mistake of judicial supremacy. We could all check it out. We could move the Supreme Court to a strip mall in Clarendon as part of a modernization and transparency effort. Could give them their own Chick-fil-A. Would work out well. Professors, why don't we start with you, Nico? One way I've thought about this scheme, it was really smart, right? They knew they couldn't get their agenda passed through the ballot box, like Lisa said. And so they studied the Constitution. They studied the kind of democratic parts of it and the anti-democratic choke points that the framers very intentionally put there. They saw a ton of potential in the court. Concentrated, unaccountable, insulated by life tenure, with the power, according to all of us, we've all accepted this, to decide exclusively and unilaterally what the Constitution means. And they leveraged that insight into this judicial capture program. They built that power. They've consistently aggrandized that judicial power while weakening the legislative powers of Congress, the people's most directly reflective representatives in Congress. So, Nico, maybe you could talk us through where this notion of judicial supremacy came from and whether it is in fact something that we must accept, as we have for so long, without question. This is the thesis of your book, right? That we don't actually have to just take this lying down.
Yeah, that's right. And so, we're about to commemorate the 250th anniversary of the United States declaring its independence from a monarchy. And let's just consider where we are right now, because the United Kingdom has recently had a change in monarch. When Queen Elizabeth passed away, no one lost their rights. The people in the United Kingdom did not lose their ability to vote once there was a change in monarch. The biggest change there was someone's face on the coins has shifted. Whereas here, when Ruth Bader Ginsburg passed away, our rights transformed. Our ability to solve our problems changed. Our ability to have a Voting Rights Act, or to have campaign finance laws, or to have reproductive justice, or to be able to do anything about climate, or to be able to have labor protections, or to be able to have redistributive legislation transformed. And if you listened to the justices, they would insist that we must live under their interpretation of the Constitution until one of them dies or retires, perhaps on their own timeline, with the ability to choose their successors. That's what it means to have judicial supremacy. That's what it means to accept the idea that when it comes to interpreting the Constitution, we, the American people, have no say, but 9 justices on the Supreme Court do. And it was not always this way. The first time that the Supreme Court disagreed with Congress about the meaning of the Constitution was a case in 1857 called Dred Scott versus Sanford. It was a case in which the court looked at a law that Congress had passed to ban the spread of slavery. And the court said, we disagree that Congress has the ability to do this. We think the Constitution protects the rights of slaveholders. And when abolitionists or the founders of the Republican Party saw that decision, they didn't say, dang, I guess we have to wait for Chief Justice Roger Taney to retire. They weren't like, oh, God, I guess, we just have to live the rest of our lives with slavery. No, they said, who are you, Chief Justice Taney, to tell us what the Constitution means? Who are you to tell the people in Congress what they're allowed to do when they legislate? And Abraham Lincoln and the Republican Party ran on a platform of the court does not get to decide what the Constitution means. We do, the American people do, and put us into office, and we will transform the Constitution from a pro-slavery document to an anti-slavery document. At his inaugural address, he told the American people, if we allow the Supreme Court to decide the meaning of the Constitution, we will have handed the power of self-government to that eminent tribunal. And only 2 years after actually 1 year after he became president, Congress passed a law that did precisely what Dred Scott said Congress could not do. It banned the spread of slavery in federal territory. And so one lesson from that story is that judicial supremacy is a choice. It is an ideology. It is a belief. But it is not something that the Constitution requires. It's not even anything the Constitution says. There are no words, if you look at the Constitution, that give the court this power to reverse Congress. By contrast, the Constitution explicitly gives Congress the power to regulate the court. And during Reconstruction, Congress exercised that power as it began multiracial democracy in this country. Congress passed the Reconstruction Acts, the first Civil Rights Acts, and laws to prohibit the court from second-guessing Congress's understanding of the Constitution. Those laws created the beginning of multiracial democracy, and they laid the foundation for the things about our Constitution that we celebrate today. But one thing that Reconstruction Congress failed to do was completely bury judicial supremacy, and in its wake, the court reasserted this control over the Constitution to undermine the progress that Congress made. The court's decision this past month was not the first time it invalidated a Voting Rights Act. The court invalidated not just the Voting Rights Act of 1965, it invalidated the Voting Rights Act of 1870. It invalidated the Civil Rights Act of 1875. It invalidated the laws that had protected this country from Jim Crow that emerged and took hold for the next generations. And it was members of Congress who believed in the same faith as those abolitionists and Abraham Lincoln, this democratic constitutionalism, who proposed the Voting Rights Act of 1965 to say, even if the Supreme Court is going to interpret the Constitution to do nothing about Jim Crow, to do nothing about literacy tests, we in Congress have the power to do something about it, and that is what the Voting Rights Act was designed to do. So when we think about what power should the court have in this country, giving it the power to have the final say of the Constitution is dangerous. It does not belong in a democracy. In a democracy, to have a government of the people, by the people, for the people must have the ability to determine what the Constitution means. And we wrote our book to try to encourage you to think of yourselves as people capable of interpreting the Constitution as a document that can have something like a Voting Rights Act, no matter what someone like Sam Alito says. And Congress has the power. Congress has used the power in the past, not just to control the court's appropriations, which it must, but also what kinds of cases the court can decide, whether it needs a majority or a supermajority or a unanimous bench to overrule Congress, whether it can do that at all, what kinds of cases it can hear, what kinds of ethical responsibilities the justices are obligated to follow. Everything the court does is subject to congressional control, and Congress must start wielding that power.
Amen. Let's get back to Calais, right? I had this really crazy meeting after, because Calais didn't, we talked about this, it wasn't like a new thing. They've been steadily assaulting the Voting Rights Act. They've actually, they forecast their reasoning in Calais for years. We could tell it was coming. Brett Kavanaugh told us it was coming in your case, right? In the concurrence, even as you won, he said, this isn't going to last long. So what do we do? Like, the conversation, sorry, I lost my train of thought for half a second. I went to meet with a senior member of the House Democratic delegation who is working on H.R. 1, a big voting rights restoration work, right? But it was clear, the writing was on the wall, that the court would call it unconstitutional. And I said, what's the plan? You're going to ask our movement to invest, God knows how many hours, how much blood, sweat, and tears, how many hundreds of millions of dollars. We're going to pass generational voting rights restoration, and the court's going to strike it down. What do we do then? How are we going to protect this bill from this court? And they didn't have an answer. The stuff that Nico and Daphne are talking about, we've left them on the table. The other tools, incredibly powerful tools that we've left on the table, they're not even part of the consideration. So Daphne, I was hoping that you could build on Nico's amazing answer to help us understand, sort of in a practical context, what does this philosophy of constitutional power in the hands of the people let us do for something like Calais? What could Congress do inspired by your vision of the Constitution?
Yeah, great. So Calais, of course, is a case that continues the project of eviscerating the Voting Rights Act, right? The Voting Rights Act is a statute that multiple Congresses, thousands of individual members, voted to enact and then reenact, that several presidents signed, that translated into the US Code the ambitions and the vision of a freedom movement, that their resilience, their sacrifice is marked on the pages of the statute. And Calais is the end of a series of opinions where 5 justices on the Supreme Court say, actually, we'd like the 15th Amendment to mean something else. We'd like the 15th Amendment to say that as long as what you say is partisan goals, then we don't need to worry about race discrimination. And that's just turning all of Reconstruction on its head, which of course was a time when, in the name of partisanship, at the time it was the Republican Party that was trying to protect multiracial democracy and Democrats that were trying to bury it, but in the name of partisanship, you had paramilitary organizations preventing black people from voting in the South. You had a series of events that were using the mantra of partisanship. The Klan was a partisan organization trying to bury the Republican Party. The White Leagues in the South were partisan organizations. So the idea that partisanship and race discrimination have been long intertwined in our country, and that Congress has passed statutes to try to address racial discrimination, recognizing the entanglement, is just a part of our history that the Supreme Court would like to pretend doesn't exist. And so what do we have to do? Do we have to accept this new interpretation of the 15th Amendment that the court is putting forward and have it control what kind of legislation Congress is allowed to enact? The answer is we don't. The answer is there's nothing in the Constitution that suggests that the court gets to decide as a final matter what the 15th Amendment can mean for American multiracial democracy, and that Congress has the constitutional authority and the constitutional responsibility to respond, to enact substantive legislation, whether it's proportional representation, and laws that make clear that the discriminatory effects, the racially discriminatory effects of voting rules are going to be unlawful in this country. Congress has that responsibility and that authority, and it can and should check the power of the court to reject those interpretations reflected in federal law. And if you look back at Reconstruction, it was not just a time that Congress, for the first time, was substantively building out what multiracial democracy could look like in the United States. It was also a time where Congress was wrestling with precisely this question. How do we create a judicial system, a Supreme Court that enforces these new equal protection guarantees that we're putting forward against rogue states and a recalcitrant president and executive, but that doesn't exercise its power to defy federal law, to reject and ignore these federal statutes that we're enacting? And so Reconstruction members of Congress were thinking, what are the possibilities on the table? Congress could declare the new Voting Rights Act to be a political question that the Supreme Court cannot second guess. That was one proposal from the author of the 13th Amendment, Lyman Trumbull. The House at the time passed a bill that then was sent to the Senate that would have required a supermajority vote of the justices before the court could reject a federal statute. So why should a one-justice swing majority get to reject what hundreds of members of Congress have signed into law, either with the support of a president or in numbers that overwhelm a presidential veto? So the House said, look, we should have a supermajority. At a minimum, it should be a significant number of justices that think there's just no other way to understand the Constitution before they're allowed to second-guess an act of Congress. Ultimately, what the Reconstruction Congress did, as a case was working its way through the courts that was threatening the landmark laws of Reconstruction, is Congress took away jurisdiction or authority of the court to decide that one question. But the ideas that members of Congress put forward are still there. They're available to us to take up today and to think about how to more structurally cabin the role of the court so that what we have is an institution that is enforcing federal law, federal statutes, and not an institution that is defying them. What we have today is a court that has taken for itself the power to say, I think the Constitution should mean something different from what this federal statute says, and therefore I get to ignore this federal statute. And what happens when the Supreme Court gets to ignore this federal statute is that a president gets to ignore it too. So our judicial supremacy has also unleashed a more autocratic presidency in the United States, where the Supreme Court has licensed an idea that presidents can ignore enacted federal law and look for coverage to the Supreme Court to say that the law violates their presidential power. So a system of constitutional government that sees the role of the court as enforcing enacted federal law is also a system of constitutional democracy that enables a rule of law where no individual, whether a justice or a president or an ICE agent, is above the law.
Thank you. So I mentioned I worked on Senator Whitehouse's judiciary staff. I spent 5 years with him, and I sometimes joke that I actually don't really know what the job of a Judiciary Committee counsel looks like. Because, you know, I'm not besmirching anybody, but, you know, most members of Congress, they're sort of like going through the motions. We've got the nominations this week. What's on the floor? What's on, legislation? That's not what it's like to work for Senator Whitehouse. We were pursuing the scheme. We were making the case, making this big picture case, day in, day out, connecting everything that was happening in the week's events to this plot to steal our country. And so, Senator Whitehouse, I wanted to ask you, like, what would it take? I think a lot of the reason for that is that, we all collectively have internalized so many of the sort of constraints of this broken political system. Yep. Your colleagues, right? And so, what would it take to push and kind of create momentum around this mentality? It's less about a reform agenda than it is about a mentality of who gets to decide, who has power.
Let me just, before I get to that, add one comment to what Daphne said, because there's a small d democratic function that is lost when the Supreme Court takes to itself the view of deciding what America should do and throwing out federal statutes. Everybody gets it wrong sometimes. If Congress gets it wrong every 2 years, there's a chance to throw the bastards out and fix it. And that power to repair when Congress has gone off course from the American people is a very significant one. When the Supreme Court goes off course from the American people, it can be generations. And particularly if you have a Supreme Court that is not willing to correct its own errors. For instance, Citizens United was undoubtedly, indisputably, absolutely wrong in its predicate finding that all this new political money it was allowing into the system was going to be transparent. We have probably $10 billion of dark money spent since then disproving that false proposition. But the Supreme Court won't go back and correct itself even though that is clearly and indisputably false. They live with the falsehood rather than fix the problem because they have a motive to produce the result. So the difference between Congress screwing up and the Supreme Court screwing up is very consequential in terms of the democratic capability of the people to respond. There was no way in the world Congress was going to pass a unlimited corporate money and yes, it can be secret statute. You couldn't get Republicans to vote for that. So you had to go to the court, and they shelter behind the protection of the court from democracy. And I think that very particular, specific, sort of political, small d democratic point adds a lot of force to what the professors have said. In these days, whoever controls the narrative controls the debate. And we have done, as Democrats, so speaking as a Democrat senator, we've done a lousy job of controlling the narrative about the Supreme Court. I mean, 5 years ago, most of my colleagues didn't even know who Leonard Leo was. And very few people still know what the Powell memo was. Very few people understand Lisa's research showing how much money got spent to capture the court, that this was minimum a $600 million project. Minimum. That's just what we know. And so this narrative of the capture scheme, the effort that got put into it, the money that was spent, the cover-ups through no fact-finding, the question who was behind the appointments of Gorsuch, Kavanaugh, and Barrett. What if we could actually prove to the public satisfaction that they were appointed by the Koch brothers political operation as part of a deal with candidate Trump and their two functionaries, McGahn and Leo? What if we could actually prove that? How significant would that be in giving us the narrative power to be able to go forward and make the repairs that we know are so urgently needed? But if you don't control the narrative, if you don't assert what is true, if you simply don't do your job of winning the argument first, then you don't put yourself in a position to make the requisite change. And if we do a very good job of making that case, it makes it very hard for Republicans to stand up and say, no, at all costs, we have to defend this court, we have to defend its dark money, we have to defend its destruction of the Voting Rights Act, we have to defend its love for the gerrymander, we have to defend all of these things that the public hates. But it comes down in the first instance to making the forceful, truthful argument that needs to be made.
Thank you. We talk a lot about how our movement is divided into silos. I think that was the product of this scheme. Leonard Leo's network operates across all aspects of American law and life. It sets the terms for everything we care about. I think we've been responding to it in our own silos, right? We're all under attack. We're trying to save our communities, protect our neighbors, advance our vision for the future we want. But we're all being held back by this one central threat. And I think it's really helpful for us to start to see that so that we can connect around a common strategy to overcome it.
And just by the way, not only do people hate the dark money that is driving this whole thing, that's the engine of all of it, they actually hate dark money more in Trump voting districts than they do in Biden voting districts. This is a super bipartisan battle to have, but we got to be willing to go and have it. We've been so weak about it that most independents trust Republicans more to get rid of dark money than they do Democrats, even though every Republican member of the Senate voted every time to defend dark money, and every Democratic member of the Senate voted to get rid of dark money. That's how bad our narrative and our argument has been.
So in this fragmented ecosystem, I think it's just critical that we really look out for each other. And I wanted to turn it back to you, Shalila, because again, you're fighting this fight right now, right? And states like Alabama don't get enough attention, right, from the Democratic Party or from the funders that put things like this together. But I think your fight is all of our fight, and I want to hear how we can be helpful. Like, how can folks in this room, in this moment, you have a case coming up soon, right? Like, how can we collectively support Black voting power in the South? Because it is all of our fight.
Well, first, you can give money. As you stated, the funding is not always there. A lot of times, states like Alabama are considered heavily red, and we're sometimes counted out. So funding is needed, and so if you would like to fund the candidates, the Black candidates in our state, that would be greatly appreciated. Like I stated earlier, we will be focused on the new 2nd Congressional District in our state so that we can have the opportunity to send our, resend Congressman figures to Congress. But you can participate not even being present outside of funding. You can volunteer to phone bank, you can volunteer to write postcards, because our problem in our state, just like the problem in the entire country, is turnout. And so we need to turn out the voters that we have present. Also, just stay aware of what's going on with the Supreme Court. We know that there will be more cases, and there will be an attack on privacy. The cases of Griswold and the cases of Obergefell, which deals with the right to contraceptives and the right to do what you want in your home. That is what could be on the chopping blocks next. That's what we lost when Roe v. Wade was overturned. And so we have to be ready for what this Supreme Court will continue to do. They won't just be focused on dismantling Black political voting power. It will be about just taking away all our power. And next up, we women have lost the right to autonomy of their bodies, right? If you need an abortion in the South, you have to figure out what northern state you can go to achieve that. And so just be aware of what is coming through our court system. I don't think we pay attention enough until it hits the headlines. And what happens in Alabama, Alabama received a 2nd Congressional District, which led to Louisiana achieving that as well. And then Louisiana has lost theirs, and now we're losing ours. And so as goes Alabama, as goes the South, and as goes the nation. And so be willing to support Alabama. Even though we may not have the leaders that are progressive, we have the people present that are progressive. And so find a candidate to support, or find a nonprofit to support, such as the ACLU, the SPLC, Alabama Forward. I represent an organization called Stand Up Mobile. And so share the information that's coming out of the state. A lot of people really, truly don't understand what's going on. You hear congressional map and people just don't understand. So do your research so you can tell the story and you can be a part of sharing that narrative. You're here present in this room today because you're considered to be a progressive leader. So take part in that progressiveness. Take what you hear here and take it back to your communities. Be willing to go out and educate people and turn out the vote. Because in order to combat what has been done by the Supreme Court, we can fight it by showing up in numbers that we have not seen before. And so give your money, give your time, and be ready to just do some work.
I wanted to conclude with two competing worldviews. On one side, John Roberts, 2009, on C-SPAN. The most important thing for the public to understand is that we're not a political branch of government.
Not true.
They do not elect us. If they do not like what we're doing, it's more or less just too bad. That's option A. Option B, President Lincoln, first inaugural address. The candid citizen must confess that if the policy of the government upon the vital questions affecting the whole people is to be irrevocably fixed by the decisions of the Supreme Court, the people will have ceased to be their own rulers. We're living in John Roberts' world. It's more or less just too bad. That's our only answer to what this court's doing. We have a choice. Do we want to live in John Roberts' world? No. What about Lincoln's? Yes. I think the choice is clear. One last thing. Lawyers are not going to save us from this crisis. Not even lawyers that are senators who have argued before the Supreme Court. Not even lawyers that are professors at Harvard Law School. Not law students, not former chief counsels, nominations counsels. We are going to get ourselves out of this. Like I said before, on every issue we care about, this court is why we've gone backwards. On every issue we care about, this court is why we can't go forward. So if you're running a campaign, an organization, a program that cares about anything, it's time to start caring about the court. If you're looking for ways to get involved, to incorporate this work into yours, please reach out. That's why we started Court Accountability. I'm so grateful to our panelists. Your work is inspiring to me. I'm going to get emotional here. 6 people took away everything we had. It's time for 340 million of us to take it back.